Hi guys, welcome to Legality Viability. Today we are going to study about the topic of criminal breach of trust, which is provided from section 405 to 409 of Indian Penal Code. So let's get started. So I would advise you to please open your Bare Act side by side so that you can get a better understanding of the concept. So section 405 reads as, whoever, being in any manner entrusted with property or with any dominion over property, dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of the property in violation of any direction of law prescribing the mode in which trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such contract, or willfully suffers any other person so to do, commits criminal breach of trust. So I have broken this down into pieces so that you can understand the definition of the offense clearly. So the essential elements of this offense are, firstly, there should be entrustment. So for example, there is a person who has entrusted his property or control over his property, that is dominion over his property, to any other person, and that another person is B, and B dishonestly misappropriates that property which A has entrusted on him, or he converts that property to his own personal use, or he dishonestly uses or disposes of that property of A, or willfully suffers any other person to do the same, which is in violation of any direction of law which is prescribing the mode in which such trust is to be discharged, or of any other legal contract in which he has made which is touching the discharge of such trust, then B will be liable for criminal breach of trust under section 405. So basically there are four essential elements, that is, firstly, there should be entrustment by any person to any other person, and that entrustment should be of any property or dominion over property. Dominion means control over that property. Thirdly, there should be misappropriation. That means that other person who has been entrusted, he puts that property to his own use without permission of that person who has entrusted him. That means misappropriation. So there is entrustment, there is misappropriation, and there of any property. Then there is criminal breach of trust committed by another person. We will understand this by illustration A. This is given in the Bare Act as well. So A, being executor to the will of a deceased person, he dishonestly disobeys the law which directs him to divide the effects according to the will and appropriates them to his own use. Then A has committed criminal breach of trust. So we can understand this in this manner. For example, A, he is the executor of the will and he has been entrusted by B, who is a deceased. So B has entrusted A that you will be the executor of my will after my death. And A, after B has passed away, he was supposed to divide the will equally among the heirs of the B. However, instead of doing that, he misappropriates the property or whatever is given in the will for his own personal use. Then A shall be liable for criminal breach of trust under section 405. If we saw the illustration, if A is liable for criminal breach of trust, then A shall be punished with imprisonment of either description, which may extend to 3 years, or with fine, or with both. So he shall be provided with imprisonment, or he can be fined, or he can be liable for both. Then comes section 407. It reads as follows: criminal breach of trust by carrier, etc. So whoever being entrusted with the property as a carrier, or as a wharfinger, or as a housekeeper, commits criminal breach of trust in respect of such property, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall be liable for fine as well. So if someone is entrusted with his property as a carrier, or as a wharfinger, or as a housekeeper, then also he has misappropriated it. He has committed criminal breach of trust, and those four essential elements are fulfilled in this case, then the person shall be liable to an imprisonment which may extend to 7 years, and shall also be liable to fine. This can be understood by two examples. So A, he is a warehouse keeper, and Z goes on a journey, entrusts his furniture to A under a contract that it shall be returned on payment of a stipulated sum for warehouse room. And he dishonestly sells that goods, and A has committed criminal breach of trust in this case. So we can understand this illustration. in a better sense. So through this, so A here, A is a warehouse keeper, whereas Z, another person, is going on a journey. So Z provides all his furniture to A and asks him to keep his furniture in the warehouse based on a contract that after a stipulated sum of amount is paid, then A shall return the same furniture of Z back to him. However, A behind Z sells that furniture to B. Then in this case, A has committed criminal breach of trust. Next is the illustration. F, this is also given in the Bear Act, please refer to it. A carrier is entrusted by Z with property to be carried by land or by water. A dishonestly misappropriates that property. A has committed criminal breach of trust. So in this illustration, A is a carrier and he is entrusted by Z, another person, that he has to carry Z's property from place 1 to place 2, either by land or by water. So what A does, instead of carrying that property from one place to another, he takes that property to his own place and he sells it. So in this case, misappropriation is done by A. Instead of doing what he was authorized to do, what he was entrusted by Z to do, he instead sells the property and misappropriates the property for his own use by disposing it off. So in this case, A is liable under section 407. Next is section 408. It reads as criminal breach of trust by clerk or servant. So whoever, being a clerk or servant or employed as a clerk or servant and being in any manner entrusted in such capacity with property or with any dominion over the property, commits criminal breach of trust in respect of that property, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall be liable to fine. So in this case, if criminal breach of trust is done by a clerk or by a servant over property or dominion over that property, then that such person will also be liable for imprisonment of either description for a term which may extend to 7 years and fine as well. Section 409 reads as Section 409 reads as criminal breach of trust by public servant or by banker, merchant or agent. So in this case, there is public servant, there is banker, merchant or agent. So if criminal breach of trust is done by any of these persons, then he shall be liable for criminal breach of under section 409. So whoever, being in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in the way of his business as a banker, as a merchant, factor or as a broker or as an attorney or agent, commits criminal breach of trust in respect of the property, then he shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall be liable to fine. So basically section 407 to 409, it talks about aggravated form of criminal breach of a trust. For example, we have seen criminal breach of trust by carrier. Then we have seen criminal breach of trust by any clerk or servant, and now we are going to talk about criminal breach of trust by public servant or by banker, merchant, attorney, etc. So in this case, section 409 talks about criminal breach by any of these persons shall be liable for either description which may extend to term of 10 years of imprisonment and shall also be liable for fine. So this is aggravated form of criminal breach of trust. We can understand this by an illustration which is provided in part E. So a revenue officer is entrusted with public money and is either directed by law or bound by a contract expressed or implied with the government to pay into a certain treasury all the public money which he holds. A dishonestly misappropriates the money and A has committed criminal breach of trust. So in this case, A is a revenue officer and he has been entrusted with some public money. A is a revenue officer, that means he is a public officer and he is entrusted with public money and is either directed by law or bound by a contract. Either he is directed by law or he is bound by a contract with the government to pay that certain amount of public money to a treasury. However, instead of paying that money to a treasury, he dishonestly misappropriates that money. So in this case also, A has committed criminal breach of trust as a public servant. So he will be liable under section 409. Similarly, we have two major cases in criminal breach of trust. So there is the case of Rashmi Kumar versus Mahesh Kumar Bhada. In this case, the Supreme Court had held that when the wife entrusts her Stridhan property with the dominion over that property to her husband or any of her in-laws or any other family member, and they dishonestly misappropriate or convert that property to their own use, then that person shall be liable for criminal breach of trust. And in this case, even the failure to hand over marriage gifts and ornaments received to the wife by the in-laws on being driven out, this also amounts to criminal breach of trust. And even taking away gifts or cash offerings from the bride by her in-laws also amounts to misappropriation. The person shall be liable under criminal breach of trust. So the next case is the state of Gujarat versus Jaswantlal Nathalal. So in this case, the government had sold the cement to the accused only on the condition that it will be used for construction work. However, a portion of that cement was diverted to a godown and the accused was sought under criminal breach of trust. Then, however, the Supreme Court had held that the expression entrustment, it carries with it the implication the person who is handing over any property to another person, that other person shall continue to be the owner of that property. And without entrustment, there is no offense under this section. And in this case, the person who is handing over the property, he must have confidence in the other person who is taking the property so as to create a fiduciary relationship between them, which was not in this case, as it was a case of mere transaction of sale, which cannot amount to an entrustment. So the accused, he just violated the conditions of purchase, and the only remedy was to prosecute him under the Cement Control Act. However, there was no offense of criminal breach of trust in this case. So guys, this was all about the concept. So if you guys have any doubt, you can write them in the comment section. I'll surely answer them. Thank you for watching.